Welcome to today's program titled A Special Multi-Part Series, Guidance on Paid Family Leave Laws, Part 10, spotlighting Delaware, Maine, Maryland, and Minnesota. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Josh Seidman. Josh, please go ahead.
Thank you, Kate. Hi, everyone. Thank you so much for joining us today for our next Paid Family Medical Leave webinar. This is the 10th installment of our Paid Family Leave webinar series that we've been doing for the last several years. As the title suggested, we are going to be focusing today's discussion on 4 laws. Those are the laws coming online in 2026 in Delaware, Maryland, Maine, and Minnesota. However, despite the laws all coming online a little over 12 months from now, there are plenty of deadlines coming up between now and then, some that have already passed, in fact. So to walk us through these 4 laws, joining me today are my wonderful colleagues, all members of our leave team here at Seyfarth, Danielle Shapiro, Christina Duslack, and Ashley Casey. I'm Josh Seidman. We are all so thrilled to be here with you today. Next slide, please. So this is a quick snapshot of where we'll be taking you over the next hour of today's webinar. We'll start off with a quick nationwide paid family leave overview. We'll then turn to Minnesota and its paid family medical leave updates, and that will be Ashley walking you through that. Then Danielle will be covering Delaware. Christina will be taking us through Maine, and I'll wrap up with Maryland and then a 2025 outlook, including some news that just broke earlier today on the federal paid family medical leave space. So some information for folks at the tail end on that, a new update as well. Next slide, please. So we're going to jump right in with our nationwide paid family leave overview. As you'll see on the next slide, there are a number of different types of laws that fall under the umbrella of paid family leave laws. You have statutory disability insurance laws, or SDI laws. That's that first group on this slide. Those are the original guard in this space. They've been around for decades. The first of these programs came out in the 1940s. So we've been living with it for 80 years, plus 80 years at this point. Those laws exist in California, Hawaii, New Jersey, New York, and Rhode Island. They provide wage replacement benefits to eligible workers who suffer a qualifying disability outside of the workplace. And 4 of those 5 jurisdictions, starting in the early 2000s with California and running all the way up to 2018 with New York, 4 of those locations, California, New Jersey, New York, and Rhode Island, then passed paid family leave laws to complete sort of the puzzle, if you would, of filling in sort of the other components of the FMLA, right? If the FMLA covers, among other things, the employee's own serious health condition, bonding with a new child, and family member serious health, right? The SDI laws covering, at least at a high level, the employee's own serious health condition in those jurisdictions. What those 4 states did was add a paid family leave mandate that now includes absences to bond with a new child, as well as caregiving for a family member who has a serious health condition, among other covered absences potentially. New York really kicked off in 2018, sort of this next wave, right? Again, New York being a paid family leave law. But as soon as New York sort of broke, there was a wave of these paid family medical leave laws, which I expect most of the folks on today's webinar are used to at this point. These are mandates that exist in a number of states: Colorado, which came online earlier this year, Connecticut, Washington, D.C., Delaware, which will be one of our focus points for today, Massachusetts, Maine, Maryland, and Minnesota, all part of our focus for today's webinar, and then Oregon, which came online about 15 months ago, and Washington State. Each of these programs, again, the paid family medical leave mandates, has time off benefits for bonding with the new child, family member caregiving, just like the paid family leave laws do, but they have that additional medical component, time off for the employee's own serious health condition. That's really where they differ, and some of these laws go well beyond that. Some laws will cover bereavement leave. Other laws might cover military exigency or safe time or public health emergency related absences. So the scope and breadth of these laws really does vary from one location to the next. But these aren't the only locations that fall under the paid family leave umbrella. If you go to the next slide, we'll see just a few more types of these paid family leave laws. Now, these are not mandates, right? Everything on the last slide was a mandate, right? It either provided a wage replacement benefit or a leave entitlement to employees who are eligible for a qualifying absence in those locations. On this slide, we have some of this newer trend of voluntary paid family medical leave programs that exist in New Hampshire and Vermont. The New Hampshire program has been online for almost 2 years. Vermont's program is being rolled out in phases, with the availability to private employers coming online in July of next year. And then you have these additional 8 states that have added family leave as a class of insurance that the states now allow insurance providers to offer an insurance package involving family leave in those states. And not a mandate, right, but a step towards a potential mandate, right, a development in the paid family leave space. And you can see the 2 newest locations there being Kentucky and South Carolina. When you bundle the locations on this slide with the locations from the slide I just spoke about together, where you've landed is 24 total jurisdictions, plus Washington, D.C., so 25 jurisdictions that have some type of paid family leave, short-term disability insurance, paid family medical leave mandates, or family leave as a class of insurance or a voluntary paid family medical leave program, completing this paid family leave patchwork in our country. If you go to the next slide, we will kick off our discussion with our state-specific focus, and we'll be turning to Minnesota first.
Thanks, Josh. So now we'll move along to an update on the Minnesota paid leave law, which is one of the newer paid leave enactments. So starting with some important deadlines on the next slide, the paid leave law was signed by Governor Tim Walz about a year ago now, a year and a half ago on May 25th, 2023. And then a few months later, on October 31st, 2024, employers were required to submit their first quarterly wage report. And at the time, it wasn't really widely publicized, but the FAQs provided some guidance as to how this would work. So at this time, the paid leave division actually combined their unemployment insurance system as well as their paid leave system. So now the same wage reports will apply for both unemployment insurance and paid leave purposes, and that's in fact true going forward as well. And in terms of upcoming dates, employers must provide employees with a notice of their right to paid leave under the law by December 1st, 2025, so about a little less than a year from now. And according to the Minnesota website, the state will provide written materials and informational posters, things of that sort, that employers can use to satisfy this requirement before the deadline. And this is something that we're continuing to watch for because the state hasn't published anything as of now. And then Minnesota is adopting a more unique approach in the sense that employee payroll deductions will begin on January 1st, 2026. This is the same date that employees may begin using paid leave. So unlike some other states where payroll deductions will begin before paid leave can be used, Minnesota is doing it all at once. And then finally, employers must make their first quarterly premium by April 30th, 2026. So the payment will be submitted through the employer's unemployment insurance slash paid leave account. Again, that's a joint account now. And the premium will be based on wage details, which are submitted between January 1st, 2026 and March 31st, 2026. So now that we've covered some of the important dates that have passed and are going forward, we can go through some of the specifics with respect to the paid leave law. So on the next slide, we'll get into the employee and employer coverage. So under the law, the term employee is broadly defined. So employees are covered so long as they either one, work in Minnesota 50% or more of the time, or two, if they work in Minnesota less than 50% of the time, they can still be covered as long as they reside in the state, or their employment and work is directed and controlled from the state. So it's a pretty broad definition compared to some other states. And in terms of employer coverage, employers are covered so long as they employ one or more covered employees, meaning an employee who falls under numbers 1, 2, and 3 of the list that we just went over. And the only exception here really applies to the federal government or self-employed individuals who decide to opt out of the program. So moving on to the next slide, again, reasons for use is pretty broad under the law here. So these reasons are going to include bonding with a biological, adopted, or foster child, caring for a covered family member, when there's a qualifying exigency, and this will involve military service or active duty, safe reasons, including domestic abuse, sexual assault, or stalking, to care for the employee's own serious health condition, and finally for medical care related to pregnancy. And this would include things like childbirth, stillbirth, and miscarriage. So some of these reasons that we just went over pertain to covered family members only. So on the next slide, the law defines covered family members to include immediate family members that you would expect, like a spouse, domestic partner, a child, a parent, and so on. But keeping with the broad nature of the law that we keep saying, covered family member also includes people like son or daughter-in-laws, as well as any person who has an expectation and reliance that the employee will care for them without compensation. So this is extremely broad. And an important note here is that this person will be covered even if they don't live with the employee. So again, very, very broad here, and this is a unique covered family member that we don't see in a lot of other states. Next, in terms of the amount of leave, employees can take a maximum of 12 weeks of paid family leave benefits or 12 weeks of medical leave benefits per year. And on the next slide, we'll go through this a little bit more. And just for clarity, when we say family leave, we're broadly referring to all of the covered reasons for use except the employee's own serious health condition. So that's kind of how the law differentiates paid family leave and paid medical benefits. So as we were saying, you can either get 12 weeks of paid family leave or 12 weeks of medical leave benefits. But if an employee needs to use both in the same benefit year, they'll be capped at a combined total of 20 weeks of leave. So you're not completely out of luck if you need to use both. You're just capped at 20 weeks. And an important reminder here is that the benefit year is not defined as the typical calendar year. Rather, the benefit year starts when the employee first uses Minnesota paid leave. So technically, each employee could have a different benefit year because it depends on when they first use the leave. So a little bit of an administrative burden for employers, but something to keep in mind. And another reminder too is that benefits can be used by employees on a continuous or intermittent basis. So all 12 or 20 weeks do not need to be used at once. That's a common question that comes up too. So moving on to the next slide, Minnesota has provided us with a rather complicated looking equation for calculating paid leave benefits. But to boil this down, Essentially, this means that employees can receive up to 90% of their wages while taking leave. And currently the maximum is set at $1,337 per week, and that's equal to the statewide average weekly wage. So that will probably change per year, but these are current as of January 1st, 2026. And another common question that we get among employers is who will be paying these employees while they're on leave? Well, recently the FAQs were amended, so now it's pretty clear that employees will receive weekly payments directly from Minnesota State. So the good thing is that employers don't really need to worry about this too much because they won't be super involved in the process. And on the next slide, we'll get into funding. So the paid leave program is funded through both employee contributions and employer contributions if the employer chooses. And what I mean by this is that at a minimum, employers must pay 50% of the annual premium cost. From there, employers can choose to have employees pay the remaining 50% through payroll deductions, or the employer can instead choose to pay the entire premium amount on behalf of their employees. So assuming that employers decide to have employees pay their 50% or whatever the percentage may be, employer contribution rates will depend on whether the employer participates in the state's family and medical leave benefit program or opts to use a private plan. So for example, employers who rely on the state program will have a 0.7% contribution rate, whereas if you opt to use a private plan for either family or medical leave benefits, you'll have between a 0.4 and a 0.3% contribution rate. So it differs a little bit. And then again, employees must pay the remaining portion not paid by the employer, assuming the employer does not opt to choose to pay the entire amount. So on the next slide, we'll get into private plans, which I alluded to a little bit. And unfortunately here, we don't have a ton of information because per the Minnesota website, we're gonna get this rolled out periodically in 2025. But for now, what we do know is that private plans, whether it be family or medical, they must provide at least equal benefits to those under the law. So what that means is that private plans will not be approved if the benefits are less generous than what the law requires. And when the state does finalize its application process, which has not been done yet, it appears that employers will not only need to choose a plan that meets the requirements laid out under the law, but also submit proof of coverage. And again, this is something that we're keeping an eye on to determine how employers must do this and what the deadlines are. So we'll keep an eye on the Minnesota website as well as FAQs and regulations once those continue to be rolled out into 2025. And then finally on the last slide, we'll get into some notice and posting requirements. So the state is set to publish a sample poster, which needs to be posted in a conspicuous place in the employer's workplace. So it can't be somewhere like a closet where only some employees go. It should be on like a bulletin board or near a time clock, something where a lot of employees frequently visit. And we think that in addition to being published in English, the state will also probably publish the poster in other languages because the law requires employers to publish the poster in any language that's spoken by 5% or more of employees. So again, that's something that we'll keep an eye on. And then as we talked about in the beginning of this section, a notice of rights must be distributed by December 1st, 2025, which is 30 days before the law goes into effect. Thereafter, if any employees are employed after December 1st, 2025, the notice just must be provided to them within 30 days of their hire. And then finally, employees' pay stubs or earning statements must show what amount was deducted for paid leave benefits. And at this time, the law and the FAQs are pretty silent with respect to written policy requirements, but this is something that we're keeping an eye on because we definitely expect additional guidance will be rolled out through 2025 and maybe even into early 2026. So with that, I'll turn it over to Danielle to give us an update on Delaware.
Good afternoon, everyone. Like Ashley just said, I will be providing a little bit of information about the Delaware Paid Family Medical Leave Act. So if you go to the next slide, I'm going to start off by just covering some of the key provisions of the Act. The first has to do with covered employers. So employers with 10 or more employees who physically work in Delaware are covered by the Act. I'll mention there's also a provision for telecommuting employees. So if an employee works on a Delaware team and telecommunicates into the state for over 40% of the time, they too may be eligible for benefits, but the employer and the employee must sign a reclassification form. Which specific provisions of the Act, however, apply to the employer depends on the number of employees that an employer has. So employers with between 10 and 24 employees are subject to the parental leave provisions of the Act, and employees with 25 or more employees are subject to all kinds of leave. Employees who have worked at least 12 months and at least 1,250 hours for their employer in the prior 12 months are eligible for leave under the Delaware Paid Family Medical Leave Act. And the Act provides 4 different kinds of leave. The first is parental leave for birth, adoption, or placement through foster care, and this kind of leave is available for the first year following that bonding event. The second kind of leave is medical leave for an employee's own serious health condition. The third kind is family caregiving leave for an employee who needs to care for a family member with a serious health condition. And the fourth kind of leave is for a qualifying exigency, such as active military duty. According to the Delaware Paid Family Medical Leave Act, family members are defined along the same lines as the FMLA, so that would include children, parents, and spouses. We can move on to the next slide. So the next provision that I'm going to talk about has to do with the amount of leave provided. And the Delaware Paid Family Medical Leave Act provides a maximum of 12 weeks of leave for all leave reasons in an application year. However, depending on what kind of leave an employee is taking, there are some different parameters. So for medical, family caregiving, or qualifying exigency leave, an employee is eligible for 6 weeks of leave in a 24-month period. For parental leave, an employee is eligible for 12 weeks of leave in an application year. And this term application year is kind of structured similarly to the FMLA, so it may sound a little bit familiar. But one thing that we wanted to point out is the difference here between the 24-month period and the application year is a little bit more difficult. The current regulations do give some guidance on the interplay between these two terms, and we expect that there may be further regulations that shed some light on this as we get closer to when the Delaware Paid Family Medical Leave Act goes live. Moving on to the next topic, I'm going to talk briefly about amount of pay. So employees are eligible to receive 80% of their average weekly wages during the 12 months preceding application submission under the Delaware Act. This sets a floor at $100 per week and a ceiling at $900 per week. And finally, for employee contributions, the rates, employee contribution rates for each type of leave are on the screen. So you've got 0.4% for medical leave, 0.08% for qualifying exigency and family caregiving leave, and 0.32% for parental leave. Employers may deduct up to 50% of the cost of the plan from employee wages, or they may opt to cover 100% of the plan on their own. It just depends. So moving on to the next slide, I've laid out some important dates for employers to keep in mind as we get closer to the Act kind of ramping up. But first, I thought we would go all the way back to the beginning. On May 11th, 2022 is when the Delaware Paid Family Medical Leave Act was signed into law. About a year later, on July 11th, 2023 is when we saw the first round of regulations go into effect. And then a little bit less than a year after that, on March 11th, 2024, the second round of regulations went into effect. And then that brings us to the fall of 2024. In the fall of 2024, all employers should have or should be setting up an account using Delaware Labor First, which is a helpful tool that employers can use to make sure that they're staying up to date on all things Delaware Paid Family Medical Leave. And this account needs to be set up either prior to the first remittance, if an employer is going to be using the state plan, or prior to applying for private plan approval, because the approval goes through Delaware Labor First. So the private plan window opened on September 1st, 2024, and ran through 2 days ago. It ended on September 15th, 2024. And I just want to flag that this was an extension. It used to end on December 1st, 2024. And though that time period was extended, the application window for self-insurance remained December 1st, 2024. Also on December 1st, 2024, employers should have provided notice to their existing employees about upcoming contributions. And I will get into this more shortly, so I won't get too ahead of myself, but that is important to keep in mind. Moving into January 2025, employers who will be going with the state plan can begin payroll deductions for employee contributions. And they'll need to do this in order to make their first remittance to the state on April 30th, 2025. Then, as we get into later 2025, back into the fall, we kind of cycle back to where we just finished up. As the period to renew private plans reopens, employers will again be able to do this via Delaware Labor First, and we can expect that this window to renew private plans will occur annually going forward. And then that brings us to 2026. On January 1st, 2026, benefits begin and employees can begin submitting their claims. So moving on to the next slide, I thought that I would just highlight a couple of areas of the Delaware Paid Family Medical Leave Act where there's been lots of discussion kind of as we hit these deadlines and move into 2025. The first is notice and posting requirements. So in terms of timing for that initial notice, kind of the golden rule here is this like 30-day rule, I suppose. So essentially, employers can't start deducting from employee paychecks until the employees have been given notice of the withholding. And they need to have that notice at least 30 days before they would see the effects of the withholding. So if you're an employer who's going to be going with a state plan that intends to start withholding on January 1st, you need to let your existing employees know 30 days prior, and that's where we landed on that December 1st, 2024 notice date. As for the requirements of a notice, so going forward, employers should provide notices to employees at the time of hiring, and when an employee requests covered leave or the employer acquires knowledge that an employee's leave may be for a qualifying event. Employers can provide notice via work or personal email addresses, either is fine. And we would recommend that employers check out the Delaware website for a model notice. We've also linked it on the PowerPoint here. As for posting, like the notice, there is a model poster posted on the Delaware website, so be sure to check that out. And employers will be required to post the notice in English, Spanish, and any other language spoken by at least 5% of their workforce. So moving on to the next slide, the last thing that I wanted to do was talk a little bit more about private plans. And I know I mentioned this earlier, but employers can choose to provide paid leave through a private plan, either a DOI-approved insurance policy or a DOI-approved self-insured plan. One important thing, though, is the plan cannot charge the employee more than the state plan would. And as I kind of alluded to before, there's this application and approval process through Delaware Labor First, in which the state is making sure that each private plan meets the substantive and administrative components that are required. So employers should have, hopefully, if they're planning to opt into a private plan for this year, use Delaware Labor First to initiate the approval process. Like I said, this process is going to repeat yearly going forward, and you can expect that if you submitted for approval this year, that Delaware should let you know by January 1st, 2025, whether your private plan has been approved or denied. If it's been denied, you will just automatically be enrolled in the state plan, and it will go on. And then in terms of notice, if you're going to elect into a private plan, again, we recommend that employers follow that kind of golden 30-day rule, providing 30 days notice in advance of a withholding. But if you're going with a private plan, we recognize that contributions may start later than January 1st. So if that's the case, just making sure you provide that 30-day notice in advance of whatever date those contributions will start. And then the last thing I wanted to mention before I wrap up is the Delaware Paid Leave website is a super helpful resource in keeping up to date as we see the Delaware Paid Family Medical Leave Act ramp up. There are PowerPoints and FAQs and webinars and a benefits contribution calculator that's really helpful. They also did a great job of updating the website just a couple of weeks ago when they made that tweak to the private plan window, so it's a really great way to stay up to date on all things Delaware Paid Family Medical Leave. And with that, I think I'll pass it on to Christina for an update on Maine.
Great. Thanks so much, Danielle. We can go to the next slide. So we've had some updates in Maine recently. As you can see, December 6th, 2024, the final rules are adopted. So we're going to go through a lot of the things that we've learned recently. But just as a reminder, the big thing that employers should be focusing on is January 1st, 2025. All covered employers must start collecting contributions. One of the things that is really important for employers to know is that even if you do want to have a private plan exemption, you can't apply for it until April 1st, 2025, which means that everyone needs to be collecting contributions starting on January 1st. So that's my big takeaway from this whole presentation. If, just keep that in mind. It's coming up in 2 weeks, believe it or not. The other thing to keep in mind is that the wage report, the quarterly reports, and the remitting of those contributions is going to be due April 30th, 2025. I'll talk a little bit about, for those folks that do try to apply for a private plan, what that will look like, but just note April 30th, 2025 is when that first quarter report is due. And then benefits for this program do not start until May 1st, 2026. So we will definitely be speaking about this law again, but we want to give you the information you need to start planning. So we're going to go to the next slide here. Most employers are going to be covered by this law. Like all of these PFML laws, it's basically become one or more, with the exception of a couple we've heard today. A shout out to Delaware. So one or more employees, you're covered by the law. Public employers, with the exception of the federal government, are covered. Private employers, regardless of size, and then self-employed individuals can opt into the program. Next slide. So in terms of employee eligibility, here are all the things that we need to be thinking about. So covered employees includes most employees with a couple of exceptions. I'm not going to go through all of them. They're very nuanced. They're things like employees subject to the Railroad Unemployment Act, or employees who are incarcerated in certain Maine correctional facilities, students on federal work-study programs, volunteers, and again, employees of the federal government, including employees of the United States Post Office. Those are some of the key ones that are not included. An employee has to earn 6 times the state average weekly wage during the first 4 of the last 5 completed calendar quarters. And so currently that number is $6,868. That number can slightly change year to year, but that's basically what we're looking at. Employees do have to submit an application for benefits. It has to be 60 days before the anticipated start of the leave, and it can't be later than 90 days after the start of the leave. This is interesting. This was in the rules that we saw. The individual has to be employed as the date of the application for benefits if applying in advance of leave, or be employed as of the date of leave beginning, if applying retroactively for the leave. Can have be considered ineligible for committing fraud, and have to satisfy the reasons for use. All right, we're going to go to the next slide. And I do have a question here. Minnesota generally with our private, all right, well, I'll cover that after. Let's just keep moving here. So lots of reasons for use, the typical ones we know: family leave, like bonding with a child or caring for a family member with a serious health condition, the employee's own serious health condition. A couple of interesting ones that are slightly different than what we normally see: organ donation, safety leave. So if you are a victim of sexual assault, there's certain military, caregiver leaves, and those related to the death of a military family member. So pretty broad reasons for use. All right, we're going to go to the next slide. Covered family members, again, this is, again, very broad, similar to what we're seeing with most of these laws now. The one kind of family member coverage that I do want to highlight is this category of an individual that has a significant personal bond that is or like a family relationship, regardless of biological or legal relationship. And we're going to go to the next slide here. And you can see that the rules here gave us some additional details as to what a significant personal bond is and kind of what the factor, what are the factors to be considered. And you'll see here that there's no one factor that's determinative. Some of the things that will be considered is that, if someone shares a lease or common ownership of real or personal property, is there an emergency contact designation? Has this person provided, has there a relationship of providing care in the past? Geographic proximity, cohabitation, and a number of other factors that kind of catch all that demonstrates the existence of a family-like relationship. So again, this is a very common kind of catch-all category that we've been seeing. All right, next slide, please. So in terms of how this is funded, so employers with 15 or more employees are required to pay 0.5% is their contribution, and then all employees are going to be paying 0.5% for a total of 0.1%. And then employers with less than 15 employees, they do not pay the payroll tax, but they still have to collect the employee tax and remit that. Now, employers can make the decision to cover that cost for their employees, but they are not required to. And I want to highlight that because there are some states that say, no, the employee absolutely has to pay it. That's not the case in Maine for employers with less than 15 employees. Self-employed individuals who opt in are only going to pay 50% of that premium rate. One thing I want to highlight that the penalty for non-compliance is 1% of the employer's total quarterly payroll. So that can add up. So just making sure that you're in compliance right away. The other thing I want to highlight is that telecommuters and who should be getting contributions, this is an important time to make sure you're considering who is in fact a Maine employee. The rules point to where the employee works, and they actually provide a kind of the test that is also used for unemployment. So that's generally the rule. If you're paying unemployment taxes for the employee, that usually aligns, but please speak to your tax counsel and make sure that you're looking at that correctly. We know that folks, especially in New England, are, living in Massachusetts, but working in Maine and vice versa, and New Hampshire, and, there are differences in the types of benefits that employees can receive, because though there can be an impact if an employee is not, considered to be in the right state. So the state has actually provided guidance on their website about that in the employer resources section, what employers need to know for 2025. I actually got an email about it during this webinar. So definitely keep an eye out for that. And then the 0.1% payroll tax, it is just, that is based on total wages before taxes, and it's capped at the Social Security wage limit, which, as you all know, is set each year. All right, we're going to go to the next slide here. So the weekly, the maximum weekly benefit amount is $1,144.67. That will change each July 1st. And the way that this will work is similar to a lot of these programs, where half of the employee's wages, that first half is the benefit is going to cover 90% of the employee's average weekly wage, and then any wages above that 50% of the state average weekly wage is going to be about 60% of their average weekly wages, and then again, it's going to be capped that no one's going to be getting more than $1,144.67 per week. So, for example, an employee that's earning $35,000 a year, their benefit's going to be about $580 per week. $57,000 a year, it's going to be about $859 per week. And then once you hit $90,000, you're going to be capped at that maximum weekly benefit amount. All right, so we're going to go to the next slide. So Maine is no more than 12 weeks of benefits per benefit year. And so that's going to be, it can be a combination of medical and family, but 12 is the total cap. And then leave can be continuous, intermittent, or reduced schedule. And so the way that the increments of use work for that intermittent or reduced schedule leave is the employers are only required to, or it's basically not less than a scheduled work day. The employer and the employee may agree to have a smaller increment as long as it's not less than 1 hour, probably for administrative purposes in terms of the state paying. All right, we're going to go to the next slide. So job protection, and this is something that was really interesting to get more details on in the rules. So Maine, the way the job protection provision works, the Maine employee has to work for a covered Maine employee for at least 120 days prior to the start of the leave. And the guidance that we've received from the state is that that requirement is portable, and it means that it's not necessarily working for that one employer. They have to be working for a Maine employer. So someone could transfer jobs, and they could still be subject to that job protection. And then even if they're not, we just want to remind employers to proceed with caution because there is an anti-retaliation provision in the law. So there still is risk for, terminating someone, immediately following their leave, as is typical. All right, next slide. Okay. So the private plan exemption, and I think there's a lot of questions about this. So employers can apply for a private plan substitution, and you have to show that you have a substantially equivalent plan, so same rights, protections, and benefits. Employers cannot apply for the private plan exemption yet. That's not going to be available again until April 1st, 2025. So what that means is that employers are going to have to pay at least 1/4 of premiums for a program that they're never going to use. A lot of folks aren't happy about that. The one thing that you should keep in mind, though, is that employers must refund employee withholdings made prior to the private plan being approved within 30 days from approval of the substitution. And then failure to do so can result in a revocation of the private plan substitution. All right, we're going to go to the next slide here. So we got some additional insight into coordination of benefits. So there's no reduction of Maine PFML benefits for wages received from any other employer from whom the covered individual is not on leave. So I think this is likely a situation if someone has a job where, they can't stand, but they have another job where they can sit at a desk, like they can still get benefits for that job where they can't stand for that period of time. Employers may use PTO to top off the Maine PFML if they choose to do so. You can't require employees to use PTO, so that's one thing to keep in mind. The benefit amount is not reduced by any short-term disability or PTO benefits that an employee receives during their leave, but the employer's typical weekly wage can't exceed 100% of what they typically get. And then benefits will be reduced by any workers' compensation or long-term or permanent disability benefits. Next slide. So employers must provide a reasonable time in advance of their leave, provide notice of their leave at a reasonable time. The rules define reasonable as 30 days before commencing the leave. Of course, if there's an emergency or illness or sudden necessity and the employee is making a good faith effort to provide notice, they can do so, as soon as feasible, and the employer should try to accept that. But the key thing to keep in mind is that the law does require written notice, which I think could be really helpful for employers. And it asks that employees provide the reason for leave, the type of leave, the actual or anticipated timing and duration of leave, and any other relevant information regarding the employee's need to take leave. The rules state that an employer may not require an employee's notice to be in or on a prescribed form as long as the information provided is sufficient. So that's something to keep in mind, that you can't require your own form. If an employee text messages you the information or sends an email, that should be accepted. All right, next slide. So this is one of the most interesting parts of the law and is unique to Maine. So Maine has an undue hardship exception. And so the way that this will work is when an employee submits information to support their claim for undue hardship within 10 business days, the employer once the employer gets that information, they have 10 business days after being notified to submit information saying, hey, this leave is going to be an undue hardship for us. And that means a significant impact on the operation of the business or significant expenses, considering the financial resources of the employer, the size of the workforce, the nature of the industry, and that cannot be overcome with the amount of notice given. And so then the rules have provided us some additional guidance about what will be considered reasonable. And you'll see that, a couple of obligations here. The employer provided a written explanation of the undue hardship to the employee, demonstrating, based on the totality of the circumstance, how the absence of the specific employee and the specific timing and duration of the employee's requested leave will cause a significant impact on the operation of the business or significant expenses. The employee retains the ability to take leave within a reasonable time frame relative to the proposed schedule. So this isn't necessarily something where you say you can never take leave. It's, if someone's taking leave on Black Friday and, that's your busiest day of the year, there could be room to potentially move that, potentially. So the employer has made a good faith attempt to work out a schedule for such leave that meets the employee's needs without unduly disrupting the employer's operations. And if medical leave is requested, the employer's proposed schedule must be sufficient to accommodate the healthcare needs of the employee and the judgment of the employee's healthcare provider. So this is really interesting, and the way that I've heard this described by the department is wanting to encourage an interactive dialogue, kind of taking some of that ABA language between the employer and the employee. So this is something to watch really closely, and we haven't really seen this in other PFML laws, so it's definitely an interesting component of the law. So stay tuned there. Over the next year, we'll cover this more. And then finally, there is a required posting that is available on the website. Written notice must be provided to employees within 30 days at the start of their employment. Note that when the contribution amount changes, before you take that amount changes, you need to give folks notice 14 days prior to any change. If you fail to provide notice to an employee and you fail to post, that waives the employee's notice obligations, a 30-day requirement. There is not a specific policy requirement right now, but stay tuned. There's obviously a lot of coordination of benefits and things to consider, so we generally recommend having one in place. And next steps are, in the next month, the paid leave portal is going to be going into effect for employers. You should be registering there so that you're getting all the information you need to make sure that you comply. All right, thanks everyone. I'm going to turn this over to Josh now from Maryland.
Awesome, thanks Christina. Hi again, everyone. So as you'll see on the next slide, and you can go one more from there. So we're going to kick off the last section of our state-specific rundown today with the Maryland Paid Family Medical Leave Program. This program's benefits were originally scheduled to go online in 2 weeks on January 1st, 2025. The law was amended, pushed it back a year to 1/1/26. It was amended again, and now Maryland is coming online last of these 4 laws. That is on July 1st of 2026. So that is in nice red font, so everybody knows what that date is. We still have some companies with questions on that point. You can various deadlines and relevant factors here, including number one, that this law was enacted back in April 2022. When it goes online in July 26, the plus 4-year runway from enactment to going live will be one of the longest, if not the longest, kind of runway from enactment to going live of all of these paid family medical leave programs. Usually it takes between 1.5 to 2.5 years for these programs to go live. There were draft regulations that were released in July of this year. There then were proposed regs that were released in the last few months, with the public comment period ending just before Thanksgiving on November 18th. Payroll deductions begin July 1st of 2025. with the first quarterly premium remittance due October of next year. There's also a notice requirement for employers to provide employees with notice 1/1/2026, and then at various other times thereafter, which we will discuss in a few minutes. And those are our key dates, right, as this law continues to be rolled out over the next 18 plus months. Next slide, please. When we're thinking about employer coverage and employee eligibility, it's important, firstly, to note that coverage is broad. It applies to an employer that has just one employee in Maryland, and per the FAQs that were updated most recently in September, there are no exemptions to that. From an employee eligibility perspective, the statute states that employees who have worked at least 680 hours over the 12-month period immediately before the date on which they are set to take their leave will be considered covered. The FAQs use a slightly different phrasing. They talk about it as the 4 calendar quarters reported before the employee needs to take leave rather than the 12-month period immediately preceding the date on which the leave is to begin. So hopefully we get some clarity and work out those two sort of distinctions, but in a pinch, defer to what the law sort of calls for. Self-employed individuals are eligible to participate. And the FAQs, there's a lot of them, I think 70 plus FAQs in the September version. A number of them discuss handling remote, hybrid, mobile workers, so a lot of good content there for you. Next slide, please. All right, so now we talk about covered reasons, similar to a lot of the laws we've discussed already today. Bonding with a new child for the first year following birth or placement with the child through foster care, adoption, or kinship care, caring for a family member with a serious health condition, the employee's own serious health condition, military exigency, and military caregiver leave, all covered by the impending Maryland PFML law. Next slide. Also have a broad definition of family member, not necessarily as broad as some of the programs that were discussed earlier today or the ones that are in existence. There isn't, as it stands today, that catch-all, any other individual related by blood or close association to the individual who's equivalent of a family relationship. But that being said, a variety of child and parent relationships are covered, as are spouse, domestic partner, grandparent, grandchild, and siblings. So a fairly broad list of covered family members here. Next slide, please. In terms of how Maryland PFML will be funded, contributions begin on July 1st of 2025, as I mentioned a few minutes ago. So that will be a year before the benefits go live. That is very typical for laws, with Minnesota kind of being an outlier here, as Ashley spoke about. But typically, right, the contributions, the funding component of these programs goes live before the benefits go live to help the program have some funding to make sure it doesn't go insolvent before the benefits start up. The deduction amount, it was announced that it would be a 0.9% of covered wages up to the Social Security cap, with employers having the ability to collect up to half of that contribution rate from their employees if they so choose. Employers can certainly be more generous and cover the employee portion. Smaller employers, those with less than 15 employees, are not required to pay the employer portion. So they would just pay the 0.45% of the worker portion. As I mentioned before, the first deadline to remit those collected deductions and the employer portion to the state will be October of next year, so the month of October, and then quarterly thereafter. Very importantly, a lot of these laws come with both remitting and reporting requirements. A lot of you online today are likely used to those and familiar with those. The Maryland program has an interesting wrinkle, which states that there will be quarterly wage and hour reporting obligations for all employers. That includes employers who are under an approved private plan. So something that's important to keep in mind there. Next slide, please. As far as the amount of pay, starting July 1, 26, when these benefits go live, there will be partial wage replacement, replacing potentially up to 90% of the employee's average weekly wages to the extent that individual's average weekly wage is 65% or less of the statewide average weekly wage. That will be the percentage amount. Then there's a wacky formula, which a lot of states have these type of wacky convoluted formulas. Thankfully, a lot of the programs have these calculators online that can help us not have to do the math involved with these things. It all boils down to that there will be a maximum weekly benefit of $1,000, at least for the first 6 months that the benefits are active and live. And then starting in 2027, that amount will be reassessed on an annual basis. Next slide, please. 12 weeks of benefits in an application year is the amount of leave that is available to eligible workers for all the various covered reasons that we discussed earlier, with one exception. There is an additional 12 weeks of benefits that can be available to the individual if they are qualifying for both parental leave and their own medical leave for their own serious health condition in the same application year. If that happens, then they could be entitled to up to 24 weeks of paid family medical leave benefits in an application year. These benefits are available both on a continuous and intermittent basis, with the increment of use established being no less than 4 hours. The benefit also provides a job protection, right? So this is one of those wage replacement plus leave entitlement laws. There is an exception, for a cause where there's a substantial and grievous economic injury, assuming the employer can demonstrate that and give notice to the worker of the denied restoration and reemployment following the leave. But those are sort of an extreme bar to hit. Generally speaking, employees will need to be reinstated to the same or an equivalent position following their Maryland paid family medical leave. Next slide. Private plans, we've talked about this a lot for the other jurisdictions. Kind of a wait and see in Maryland. There will be a private plan option, but the private plans are not on the market yet, according to the most recent FAQs. There will be a fee that will apply of between $100 and $1,000, depending on whether the company goes with a commercial plan or a self-insured plan. Once they are approved for a private plan, the FAQs indicate that the employer will not have to make contributions to the state. However, as I mentioned a minute ago, employers under a private plan will still have to submit those quarterly wage and hour reports to the state that include claims data for each quarter. Next slide, please. All right, and this is our last one for Maryland. There is a notice obligation, as I mentioned earlier. The first one for all current workers will be January 1, 2026, and then for all new hires thereafter, annually thereafter, and at times when the employee requests leave and the employer knows that the employee's leave request may qualify. As of now, no posting and no written policy requirements, although written policy requirements are always strongly recommended in this space. All right, next slide, please. This is our CLE code. You can just scan the QR code here. The code for today's webinar is SS, as in Seyfarth Shaw, so SS1222. Again, that is SS, as in Seyfarth Shaw, 1222. All right, next slide. Just to wrap up for another couple of minutes here with our federal and state outlook, if you go to the next slide, we've talked about those first 3 bullet points a lot today. Go one more slide back, please. Thank you. So what's next? What could be coming in 2025? Maybe even in 2024. There's a very slim chance we could see some movement in Michigan. The state is making a real push because they have a democratically controlled state legislature for another few days until next year. So the state is making a push for potential PFML. So keep an eye on Michigan for the next few weeks and into next year, certainly. Other places, though, Hawaii, New Mexico and Virginia both came very close last year during the 2024 legislative cycle. So I'd put both of those states, as well as Hawaii, Vermont, and Illinois, all on the radar for next year. 2023 and 2024 saw a lot of activity at the federal level that might have gone unnoticed through House and Senate bipartisan working groups dedicated to paid family medical leave progress. One of the big outcomes, and this just is hot off the presses from an hour or so ago, is that the House of Representatives introduced, and with support from a bipartisan members in the House and bipartisan members in the Senate, an Interstate Paid Leave Action Network piece of legislation. This is a really important step forward for employers looking to solve some of the complexities of this patchwork. At a very high level, the I-Plan would look to harmonize differences between the existing patchwork of paid family medical leave laws. We'll be doing a whole webinar focused on this topic in 2025, some more to come there. But keep an eye out because this is news that just dropped as of a few hours ago. And keep in mind, Trump administration, plenty of unknowns, generally speaking, and certainly on what could be coming in the paid family leave space. Next slide, please, and then go one more. So paid family leave, as you've heard today, is incredibly complicated topic. Lots of moving pieces, density, administrative challenges and compliance burdens. We have a number of resources that can help. A lot of folks on today's webinar take advantage of these resources. We have a premium paid family leave survey that breaks down all of the laws topic by topic. You can reach out to paidleave@seyfarth.com for more information. You can also sign up to our mailing list where you can get information on our legal updates and blog posts and other developments. It's free to sign up. The link is there for you. If you go to the next slide, you will see other resources include this webinar series. We have recordings on YouTube, which is a slightly personally terrifying fact, but they're all there for folks to review if you so choose and want to spend some downtime during the holidays with paid family leave. By all means, we've got 9 other hour-long parts waiting for you. And we have a Take It or Leave It podcast that I have the pleasure of hosting. We have 37 episodes, all dedicated to leaves and accommodation issues for employers. Episode 37 just dropped yesterday. So please do take a listen if you haven't had a chance to go into some of those podcast episodes. And with that, thank you everybody for joining us for today's webinar. We really appreciate your time. Thank you very much. Looking forward to talking with you all in the new year. And I will say that for anyone in the paid sick leave space who is dealing with the challenges that those laws create, we'll be having another year-end wrap-up and forecast webinar tomorrow. I believe it is at 3 p.m. Eastern. So hopefully we'll see some of you there. Thanks, everyone.